Any mention?
May I please, Your Lordship? I beg to mention item number 14, Lordship. 14.
Yes.
Due to personal difficulties, Lordship.
And for the petitioner, my lord, I have no objections.
When? When do you want?
After 2 weeks, Lordship.
14.
Offence.
Give the request to the petitioner. Yes.
May I please, Your Lordship? I beg to make a mention of item number 5, Your Lordship. The senior counsel here is out of station.
5. Samarisha is out of station.
Yes, Your Lordship.
Yes. When you are there?
Your Lordship, next week.
Next week by?
Thursday or Friday, Your Lordship.
This is a service matter.
This is
LA case, my lord was pleased to call for the copy of the award, and the award copy we have produced it.
After the week, the request.
Your Lordship, similar prayer for item number 11, 12, and 13.
11?
11, 12, and 13.
11, 12, and 13. Which the other side?
I'm there, Your Lordship.
Out of station.
Let it come after 3 weeks, then, Your Lordship. Come after 3 weeks. Because off and on, when this matter are listed, adjournment will be sought.
Yes.
After
Is
3
it
weeks.
Just say 11 to 13 after 3 weeks at the request.
Much obliged.
Yes.
Your lordship, I would like to mention item number 16.
Number 16.
Yes, your lordship.
Yes. 16.
This early morning only the council has been hospitalized, your lordship. So that's why please may fix this matter on Monday or next week.
After a week.
No, Monday,
Will not give a fix.
then after 1 week.
After 1 week. No objection. After 1 week, the request to the appellant.
God bless your lordship.
Please, Your Lordship. Lordship, I beg to mention item 6 and 7, Your Lordship.
6 and 7.
Lordship.
Yes.
Lordship, in this matter, I'm supposed to file a rejoinder, Your Lordship.
Yes.
In this matter, I'm supposed to file a rejoinder, Your Lordship.
Rejoined.
Lordship, I'm informed that the signed petition will reach today, Your Lordship. So,
2017 matters pending for filing of rejoinder. Why? Why such a long time for filing rejoinder?
We're supposed to file a rejoinder to our affidavit. Now we file our affidavit on November.
Okay, you are newly imputed. You filed your affidavit recently.
November
2022. Until now, no rejoinder has been filed. So, how long will it take?
1 week, Your Lordship. Positively, I'll file my rejoinder, Your Lordship.
See, you're asking of 1 week is useless. It take 1 year's time, we'll adjourn it for 1.
My apology, Your Lordship.
Yes. Well, just say Mr. So-and-so. Oh, just say at the request of Mr. So-and-so, Learned Counsel attend for the petitioner. Further 2 weeks time is granted for filing a rejoinder in the matter. Rejoinder against the affidavit of phone number?
7, Your Lordship.
You are filing rejoinder only against the affidavit?
Yes, Your Lordship.
Against, okay. Rejoinder against the affidavit. Yes.
Hello, my Lordship.
My lord, item number 9, I am for the petitioner, Akhtar Ali, my lord.
Yes.
Here, my lord, I am challenging the advertisement which was floated by the principal of the school. Now, my lord, I was told that the managing committee is there now. So, if that is the case, my lord, my matter will become infectious. But I just want 1 week time so that I will cross-check it, my lord.
Who is the other side?
Mr. KP Bhattacharya, my lord, for the state. But he is not the
You
High
are
Court.
for the petitioner.
I am for the
Then
petitioner,
you have to go there.
my lord.
You put it on your side.
My lord.
Just see. This is after 1 week.
After a week, my lord, I will just confirm, my lord.
The request. Yes.
Lordship.
Yes.
I beg to make a mention for item 8, Your Lordship.
Yes.
I'm praying for a week's time, Lordship. 2 weeks'
This is a
time.
quashing application.
Lordship.
No objection, my lord.
This also. Make it 2 weeks. No, so
Similar
Obliged,
prayer
Lordship.
for item 10 as well, Your Lordship.
item 10.
Yes, Lordship.
Who is there in item 10? No one is there.
No objection, my lord.
You are there in item 10 also.
Yes, your lord.
Same order.
Obliged, lord.
Daily causes item number 1.
It on merits, but on account of certain orders passed in the PIL, my lord.
My lord, we have received the response, my lord. We'd like to file through an affidavit, my lord.
You find an objection.
Yes, my lord.
But then if it is connected to that PIL, what this court can may not be proper.
In fact, my lord, before filing this Zimmer petition, we have already moved an application for modification of the order. So, my lord, we will see how that proceeds, my lord, because
You get that stay, then what is the use of keeping it pending here? Then?
my lord, because the Zimmer petition was not decided on merits. That is the
That is why
problem.
exactly. But
And-
then if you can get a favorable order in PIL,
Yes,
get the modification, then you have to go and approve the trial court again. You cannot get any relief here. If you manage to get any order, if you ultimately get successful in getting any order in PIL, then what happens? You have to go and approve the trial court again. What is the purpose of keeping it pending?
no, but, this application can be my lord, remanded back and then
Anyway,
let them file.
Sangipta Learned Council applying for the state submits that an objection will be filed in this matter. Objection on behalf of the state will be filed in the matter. And praise for grant of
2 weeks time.
2 weeks. Yes.
Item number 2.
May it please your lordship.
Yes.
Lordship, this is regarding grant of parole, your lordship. So far the state of Meghalaya is concerned, your lordship, we don't have a parole policy, your lordship.
Then what is to be done in such a case?
Lord,
My lord, sorry, my lord, just to interrupt.
Wait. Just allow the senior counsel to just.
lordship, we don't have a parole policy, your lordship. Since it is only a case for disposing the representation, your lordship may dispose of the matter by directing the competent authorities, your lordship, to take a call on the representation, your lordship.
Yes.
My lord, my humble submission is that, my lord, that we have filed a representation, my lord, for grant of parole, my lord. The state has to reply, my lord.
So that is what. So you also want the disposal of the representation.
Yes, my lord, but they have to reply first, my lord.
That is
Whether-
what. So that is what you are. We will pass an order giving them some time to dispose of the representation.
Lordship,
Yes. This petition has been filed. Raising grievance against inaction on the part of the state. Respondents to respond to the representation filed by the petitioner. Where is that representation?
Annexure 2, my lord,
Page.
page 69.
What is it? Just last line. Just one. This presentation dated 25/11/2023, filed by the petitioner. Filed by the petitioner. 25/11/2020. For filed by the petitioner for grant of parole. for 3 months to enable him to meet his ailing mother. But additionally, 100 AG again for the state submits that since a limited prayer has been raised in the writ petition, since a limited prayer has been raised, the writ petition can be disposed of by directing the respondent number
Respondent number 1. Respondent number 1, 2, 3, my lord.
the representation
We
is
have
filed.
we have filed a representation to respondent number 2 and
Let it
respondent
be
number 3.
Number 3, Your Lordship. Let the R3 will take a call, Your Lordship, on the representation. Because that representation has been addressed to the R3.
Both 1 and 2, this 2 and 3.
Yes,
2 and
yes,
3,
my
Your
lord. 2 and 3.
So either of let either of them do there is
Lordship,
no
yes.
problem by directing the respondent number
Let it be 3, Your Lordship. The Inspector General, because he's
by
higher.
directing the respondent number 3
Lordship, yes.
to dispose of the same within certain specific period of time. Can give paragraph in view of the submission made. This writ petition is disposed of by directing the respondent number 2 to respondent number 2 to dispose of the application for grant of parole dated 25/11/2023 filed with the petitioner within a period of
Let it be within 3 months, Your Lordship. In the meantime, Your Lordship will ask the department to frame some kind lines, Your Lordship.
My lord, my learned senior in the last occasion had sought adjournments, my lord, for filing affidavit.
Let it be 45 days then, Your Lordship.
1 month.
Let it be
Within a period
45
of
days.
1
Your
month
Lordship.
is all right. You have to
45
take a
days.
decision on it. It's a call only. It is not that you have to undertake hectic exercise within 1 month. Then you say, then in the above direction, the writ petition stands. At the beginning, you just say hard line counsel. Yes.
Apply, Your Lordship.
Highly obliged, my lord.
Item number 3.
Please, Your Lordship. Your Lordship, I have received the compromise deed, Your Lordship, from the.
Yes.
And from this compromise deed, it appears that all the accused persons are not party in this compromise deed.
Is it?
They're not a
One
party, but
accused
in
person
this
is there.
criminal petition, they're all a party in this. This criminal petition before your lordship, they're all a party here.
No, but then whatever the compromise.
The
This criminal
compromise
compromise
is
are
only
that-
the informant is a party and one of the accused
Accused.
persons.
This
Are.
criminal petition is based on this compromise. So if
Yes.
if they are not a party to the compromise, then which way you can assume that there is a compromise?
That is what, there's a defect in the compromise.
Because there's a counter FIR between this two person who had executed that compromise. For in this case, which I'm seeking quashing.
The compromise has to be attained
Yes,
between the parties who are involved in the litigation.
exactly.
Now, who are the parties in the litigation and who have entered into compromise? Just to say, if the parties are same, then we'll enter. If parties are not same, we are not enter. So that is all. Are the same?
Yes, Judge. Otherwise, also, if not on settlement, also, if we go by the merits of the case and showing if there is an offence made out, also, that also we can go into that.
We will be
Also,
taking a bigger risk. In 482, we have very limited. Okay.
settlement, lordship.
Because as per
List it for hearing then.
page 31, Your Lordship, there are 3 accused persons. But in the compromise deed, we see only one
The
accused
submission of the
person.
Learned Council is that in such a case, we will not confine.
Oh, he'll not base his
But your lordship
application
may
on
be
the
allowed
compromise.
first, because I would like to show the documents of how the settlement has arrived at. If that is not satisfied, I can go into the other aspect.
See, one thing is that normally the acceptance of settlement is based on the principle of law,
Exactly.
which is mentioned in 320, section 320, compounding of offence, isn't it?
Correct.
Yes.
Now, when you find that the offence is not compoundable, then you come under 482 seeking quashing
Just for 2
on the
minutes.
basis of the
Yes.
compromise. Just please have patience.
Yes.
Now, what happens if you come to compounding? Who are the parties who can compound the offence? The parties who are involved here.
Exactly.
The complainant and the victim.
The victims
here
are also
also,
not a party.
If there are parties involved, then their compromise has to be based on this. On the basis of that, if you want to press your application on the basis of settlement,
Sure.
otherwise you proceed on your merit.
Your lordship, just for a moment, your lordship. If you kindly come to the additional affidavit, the witnesses who had signed here are the petitioner here.
Are the witnesses party?
They are the other witnesses.
Can the witnesses be regarded as party to the settlement?
Yes, because they have witnessed, they were there.
So they will become a party.
Lordship, also one fact, your lordship. Kindly see the charge sheet itself also. Everywhere, it's reflected that the party had come for a compromise. Because this petitioner number here before your lordship, petitioner number 1 is the complainant, petitioner number 2 is the
You just say,
accused in that case.
You are
There was a-
going, see,
There's a
you are
counter.
taking a longer exercise. Just tell us whether the parties involved in the criminal case and the parties in the compromise are the same or not.
Just two parties, the complainant and the accused. One of the
Are the
accused.
same? They are not same.
They are the same. They are the same.
They are the same. Okay, let us see. Who are the same? And yes,
Yeah,
madam,
I
one
just
of
want to show you, Chief. Can you see? Petitioner number 1 is the complainant.
Now let us confine to the compromise deed first.
Yes, that is
No,
what.
I'll have to show that first.
No, we'll be showing. First,
Yes.
you show us the party.
Okay,
You
okay,
said
I'll show
the
the
same
party.
party, so we want to see that same parties are.
The compromise
first,
deed is at page 6. Your
Let's
Lordship.
first of all, Your Lordship, can you go to the FIR first? Let's start from there. Lordship.
No, party is for determining the name of the parties in the.
Yeah, that's what I'm
criminal
trying to
case.
show from the
Who are
FIR.
the accused in a criminal case?
I would like
Criminal case which has
to.
been charge sheeted. Who are the accused?
There are 3 of them, Your
There are
Lordship.
3 of them.
Then who
Yes, sir.
are they party to the settlement?
No, because only one of them is a party.
So that is a
The
simple
rest is
question. I do not know why you are twisting
But I have to
things and
show.
all.
But I have to
Simple
show.
question. Is it not understandable? The question. which
I
has been put
understand,
by the
Lordship,
court?
but I have to show from the documents what it appears.
No. You come to your later part of submission, your other submission later part. First, you answer to the query posed by this court. The court is asking you a simple question: whether the parties involved in that settlement are the parties involved in the criminal case or not. Whether they're the same or not.
The parties.
All of them are not
All
parties,
of them
and-
are not a party. But can you come to the compromise? Just one paragraph, Your Lordship. I just want to show 2 groups they have mentioned as a group. Kindly come to the compromise, page
That will not help your case. We will not accept that.
page number 7 of
This
my
simple thing, we do not know why you are trying to make. What is the compromise?
additional affidavit, Your Lordship. Kindly come para number page 6 and also 7. Your Lordship. I agree, Your Lordship, because there are only two parties here. The complainant here, Sparlington Thongni. Here, the first party in this compromise. This is the complainant. Now, the second party here, Tenzing, he is the accused, one of the accused. Now, Sparlington Thongni, Your Lordship, he is not the person who is involved in the incident. He was the one who reported. Now, Sparlington.
So he is the complainant.
He is the complainant.
So he is a party
yes,
to the.
he is reporting
Yes, he is
what had happened.
There remains.
Yes.
Now come to the second party. Who are the accused?
The
Now,
accused
the accused here, Tenzing is the accused here. He's one of the accused.
Yes. What about others?
Others,
Others are
Anshuman
not
Thapa is also there. He's one of the accused. And the third accused, again, because of his.
This agreement, Anshuman Thapa.
No.
He's not, Your Lordship. But again, the contents of the compromise.
Contents will not make him a party. The content will
Why-
be
why-
applicable only to the party.
Yes, why
Today you cannot make a clause to bind me in a contract.
Lordship, I just want to point out one thing also. This Tenzing, who's the second party in this compromise, he had also filed a counter FIR. That's the reason why there was a compromise only between them.
So that is
So
all right.
Sparlington-
That is all right. Then it means this compromise. When did you arrive with this compromise? 11 September 2023.
Just
When
10
this matter
days,
was
10, 12 days after the
When this matter was charge sheeted?
charge sheet is much later. Your Lordship. That
So
was
this is a compromise before the charge sheet.
before charge sheet, during
Now,
the
if you
inquiry
want
only.
that compromise to be there, it should be after charge.
No, it was during the inquiry and then they have come before the.
Then matter should not have been charge sheeted.
Yes, exactly. That was what.
That
There
is-
was a
that-
counter.
Then that is for the investigation. But then you see, if this settlement is in lieu of Section 320 CRPC, see the judgment of the Supreme Court, where these matters are allowed to be quashed on the basis of settlement.
Exactly.
Why? Because these matters are not compounded.
Exactly.
Isn't it?
Exactly.
Now that is here also your case. So if you say that there has to be a compromise, then you have to execute a fresh compromise.
And also the nature of the injury is also very simple. It's also very simple injury.
Then
That's also one thing. And the reason.
leave aside this.
And
What are the
also
grounds
the,
taken in your
the
case?
counter FIR also is part of this criminal petition that I have enclosed that FIR, counter FIR. So that's the reason why there was a compromise only between them.
You are again harping on same thing. This compromise has no value.
Yet again, there's also one thing, Your Lordship. All the
You
parties
make
of
a fresh compromise. If there is a compromise, make one fresh compromise.
we can do that, Your Lordship.
That is what you should do. It. Why you are trying making a thing and the
Then Your Lordship,
You see,
permission, I would do
otherwise
that.
this kind of small things and all, the court will definitely be
Inclined.
open for all those compromise and all, provided it is genuine. But then we do not know why you do not want to follow the procedure. You want to skip procedures. You want to jump to certain things and do.
Hey.
Your compromise was in existence before the matter was charge sheeted. Then why it was charge sheeted? So definitely investigating authority found that is not a genuine compromise. So
All
this
of them are
compromise
not-
cannot be-
Exactly,
All of them
but
not
surprisingly,
parties
I'm shocked why did they mention the charge sheet? They've mentioned that they have come for a compromise, they've filed this, that, and all.
It's okay. But then now, see, the thing is that rightly or wrongly, then you see, like then you can challenge it, but then minus that compromise.
With
Compromise
your
may be
Lordship,
a thing.
permission, if Lordship had expressed that if I could come up now with a
see,
compromise,
Whether you should go
Just to
and
satisfy.
enter into a compromise or not, that is up to you. This court will not die. But then if you want, that should be done. We can allow you to withdraw it to
please,
fight.
please can.
File a fresh petition.
That is what you should do it.
Actually, if it's, because it's only because the party were not involved in this compromise, but the fact remains is that everyone's involved. They are the one who's heading this. So if your Lordship
but then you
permit
see,
me,
if he is compromised to be
I
acted
can-
upon,
I
they
can-
have to make a party there.
I can bring that fact before this, before your Lordship,
What fact?
that it was genuine and all the parties were involved. Maybe execute another deed.
This is a counsel.
Again.
I do not know. He is a lawyer. He should understand that a compromise will bind only the parties who are
Who are signatories.
who signs as parties. Even
Because
witnesses are
here,
not parties.
the criminal petition is signed by all.
The petition is signed, but not the compromise.
Petition is all
states.
signed by all.
So that is what then you say the compromises are not the basis.
You file a fresh compromise.
Try to simplify it. Why do you want to make it complicated?
Your Lordship permitted, I can find an additional, bring that back.
Then
Just to satisfy Your Lordship, but the petitioner here are genuinely have
petitioner
come.
means this will be improvisation of this compromise. It's not that you will argue on merits. You are not ready to accept for the court to see. You argue on merits, we will do 6. When shall we list it for hearing?
After 2 weeks, Your Lordship, for hearing.
Okay. The party submit that matter is ready for hearing.
Yes.
List it after 2 weeks for hearing.
Lordship.
Oblige, Your Lordship.
From supplementary costless hearing, item number 1.
Yes.
May it please your lordship. This matter pertains to the matter, your lordship, where the learned special judge had.
Yes.
Lordship, senior counsel was supposed to be on VC, but he is not there, so I may be allowed to reply on the next day, Your Lordship. I'll take down the.
No, no,
note of
not
the
on, not
submission.
on the same day. This court memory is very weak. There is other problem, Mr. Abraham. This will be obviously on the question of law.
Yes, Your Lordship.
That is all.
Was supposed to be on VC, but I think because there's some little problem, so.
Then you make a prayer for passing over. We'll pass it over to next week. We'll have it on next week.
That be the case then
And the request
after 2 weeks, Your Lordship.
by the
After 2 weeks, and if that is Your Lordship.
any objection, Mr. Dr. Majika? No. And the request of the respondent. He's the only respondent. In that request.
I'm the only respondent, yes, sole
This
respondent.
matter. This what do you call this online hearing? This becomes a very difficult.
Yes, yeah,
This signal goes off. It's not audible. There are breaks.
Yes, Your Lordship.
Sometimes
Today there's a network problem, my lord. In the other court also, I saw this reconnecting, connecting.
And if you cannot hear properly,
My lord.
that creates a
Yes.
lot of problem.
Right.
And sometimes it irritates you.
That's true.
With my kind of temperament, where it's up down up down every time, so it becomes quite difficult job.
But
Good.
deep.
Had a pleasure, Lordship.